How can a judge make a decision with no evidence before him?
The parent organization of Full Disclosure, the American Association of Women, found itself appealing a small claims court ruling, defending itself from highly questionable billing by a lawyer. Supporters who came to the appeal hearing in the courtroom of Judge Lawrence Cho found themselves in a surreal situation.
I was also very surprised that as you were introducing or trying to introduce your witnesses and advise Judge Cho that we were all there basically to testify on your behalf, that you were not allowed basically the opportunity to call any of your witnesses to the stand.
I wasted my day sitting there as a witness. I was never called. You were never allowed to call witnesses. We were never allowed to tell our point of view, to show our evidence to the court. So he made his judgment without any evidence.
Dr. Richard Fine has been litigating in state and federal courts for more than 4 decades. Without reservation, he can certainly be considered an expert on court procedures.
First of all, the law states that you have a right to call witnesses. No judge can take that away from you.
But the fact that we couldn't call witnesses was just one of a series of troubling issues.
What I found really unusual in this hearing was that, first of all, nobody was sworn in as a witness.
And I sat there and I listened to all the cases that were on calendar that particular day. And something that I noticed that was very strange and revealing was the fact that there was no oath taking of any of the litigants, either en masse or individually. So nobody was sworn in. I thought that was very strange.
It was amazing to see that the judge would have a conversation with the people and call that evidence.
Dr. Fine confirmed our unease was appropriate.
Witnesses have to be sworn. That's the only way that you have testimony taken. If testimony is not sworn to under penalty of perjury, it's worthless.
Another irregularity occurred when Judge Cho and the lawyer suing us disregarded our subpoena for the disputed timesheets.
I found it highly suspicious that none of the documents that were requested in the subpoena ducis tecum were actually provided to the judge. In fact, the subpoena was actually just ignored.
The plaintiff said, well, I have these records in my computer system, but there was nothing that it was submitted in writing or in documents to basically substantiate his expenses at the time, and the judge basically accepted that.
The judge did not have any real evidence before him. He did not have the timesheets, and he did not have any statement of liabilities, so he had no basis for making an award. There was no evidence of what was owed. Plain and simple, it just wasn't there.
As far as I can remember, there was nothing specific that the judge said explaining how he arrived to that amount of the award.
Once again, Dr. Fine confirmed that the conduct of Judge Cho was irregular.
It is important that if a subpoena is issued, that the judge deal with that. By not dealing with that, the judge has denied you a fair trial. Judge Curley is somebody that is way out in left field, if not beyond, if not outside of the entire ballpark.
Janette Isaacs noticed a curious communication going on between the lawyer and Judge Cho.
Mr. Zachary giving his business card to the clerk of the court, and I saw the court clerk read the back of the card and say the name Tarley, which was the previous judge's name. After that, the clerk gave it to Judge Cho.
We asked Dr. Fine if that was appropriate. He explained that giving a business card to the court clerk was standard operating procedure, but nothing more should be given to the judge.
When you go beyond that, and you put some writing on the card beyond your name, your address, your telephone number, your fax number, and your email, and you ask the clerk to give that to the judge, you are now making what is known as an ex parte communication with the judge.
Janette Isaacs thought that there was nonverbal communication between the plaintiff lawyer and Judge Cho throughout the hearing.
But it seemed like Judge Cho was being prompted, if you will, to not really do his job in listening to the case or listening to both sides of the case with your witnesses, because I think he may have been swayed, if you will.
Dr. Fine indicated that Judge Cho should have been disqualified.
Not only can a party not do that, but in addition to that, under the Code of Judicial Ethics, the judge can't hear ex parte communications from a party. And if he does that, he is automatically disqualified. That is the grounds for a disqualification right then and there. He'd be out immediately. So consequently, everything that this judge did was totally not only wrong, but was totally against the law.
Before he was appointed as a judge in 2005, Lawrence Cho was an assistant U.S. attorney who served as a deputy chief of the U.S. Department of Justice Criminals Division Counterterrorism Section. Prior to that, he was a law clerk for the notorious Chief Judge Manuel Real, the most reverse district judge in the 9th District Court of California. Why would someone of his expertise be working in small claims court?
Because he's running at the small claims court level, which is really the lowest level of a courtroom going, and he may be sitting there for a reason. And the reason may very well be that he's an elected state official as being an elected judge. If he is in that position, he may be so bad that they don't want to put him anywhere where he has any real responsibility.
Well, this was not a fair trial or a fair hearing because the procedures were deviated from in substantial ways. The denial of the witnesses that should have been able to testify in the behalf of the defendant, the lack of statement of liabilities, the lack of the enforcement of the subpoena, where the time records were requested and were just not brought by the defendant or by the plaintiff person. All these procedural things made for a totally unfair trial. It basically, you didn't get a rehearing on what was supposed to happen.
What should a citizen do if they think they haven't gotten a fair trial? Follow Dr. Fine's example.
And you just stand up for your rights, because, we aren't the same country that we used to be. We are now a country where citizens must stand up for their rights in order to have those rights heard.
Where do we begin? Our producer thinks a total overhaul is needed.
I think we have to revise our entire court system, start over from scratch.
You won't believe what the Superior Court did next. This is just a short preview, and you'll have to watch the full show to see how far the court was willing to go to stop our proceedings. You can watch the full show on public cable channels, DVD, or streaming on our website. No matter how much trouble we get into, Full Disclosure will continue to bring you the news behind the news.